Are you curious or even worried about the Expropriation Act? Hi, I'm Simon Dippenal and I'm an attorney. Recently, President Cyril Ramaphosa signed into law the much debated Expropriation Bill. It is now the Expropriation Act 2025. This marks the first update to the country's expropriation framework since the Expropriation Act of 1975. It has been in the making for nearly a decade. Unsurprisingly, the Act is already headed for legal and political controversy. Now, what is expropriation? It is the taking of privately owned property by the government for the public good in return for just and equitable compensation. The Act has ignited debate across the political spectrum. The DA and Solidarity promise court challenges, while the EFF have branded the reform a legislative cop-out. Will the Expropriation Act right historical wrongs while upholding constitutional values, or is it destined to cause more problems than it solves? I'll briefly explain the controversies, opportunities, and societal implications of the Expropriation Act. You can form your own opinion. Now, for many South Africans, expropriation invokes fears of land seizures. However, well-crafted expropriation laws can stabilize property rights by making state interventions more transparent and rule-bound. The Act aims to align expropriation procedures with Section 25 of the Constitution, which requires just and equitable compensation. There are specific circumstances such as abandoned or speculatively held land where nil compensation may be just. Disputes can be referred to the courts for final determination. In principle, this ensures adherence to fair administrative procedures mandated by both the Promotion of Administrative Justice Act and the Constitution. Despite these safeguards, top legal minds argue that certain sections of the Act, particularly Sections 7, 8, and 19, create procedural contradictions. Critics say that these provisions create dual legal mechanisms, placing the administrative determination of just and equitable compensation in conflict with a court-driven process. The Act is intended to clarify expropriation, but it could wind up further complicating our land reform agenda. This is also the first significant test of the GNU. The DA is opposed to nil compensation, and there is a broad political resistance beyond the DA. The Freedom Front Plus accuses the Act of overreach. Solidarity has concerns about business confidence and property rights, while COSATU backs the Act as a tool to expedite land reform without inflated payouts. If the Expropriation Act is implemented transparently and thoughtfully, it could facilitate land reform and accelerate transformation. The Act has the potential to activate idle assets. Large tracts of derelict or unused land could be repurposed for social housing and agricultural projects, revitalizing local economies. A workable framework could attract socially conscious investors and encourage public-private partnerships. It could even strengthen Ubuntu, which holds that community well-being and individual prosperity are intertwined. A fair expropriation mechanism could reflect Ubuntu by balancing historical redress with individual property rights. But property owners are understandably worried about the risk of arbitrary land seizure. It will hopefully reassure them to know that expropriation must serve a clear public purpose or interest in terms of the Act. Owners can challenge decisions or seek mediation under the law, consistent with the constitutional and PAJA requirements for fair administrative action. However, litigation costs could rise if there are disputes over the interpretation of nil compensation. For prospective buyers and investors, a robust expropriation regime could reduce unpredictability. Investors interested in social impact projects could benefit if underutilized land is made available, provided the courts uphold the Act in a clear manner. However, legal action threatened by various political parties may place the new land deals on hold. For communities, an effective expropriation process could aid restitution and support community-based agricultural projects and social housing, provided the processes are consistent with the Constitution and PAJA. The history of land ownership in South Africa is marked by dispossession, pain, and a search for justice. The Expropriation Act 2025 has the potential to be a turning point for inclusive development, but it could also spark fresh legal and social conflict. The Act's effectiveness and impact will depend on the integrity of its application and the robustness of the judicial system and its enforcement. The Act will undoubtedly be tested in the courts. I'll be watching avidly. If you have any questions about the Expropriation Act and how it might affect you or your property, get in touch with me on the number below.